Welcome back to City Education, your channel for education in all forms, shapes, and sizes. Now today we begin with the words human rights. Two simple words that stay debate in every corner of the world. But here's the question: are these rights truly universal, or are they shaped by culture, politics, and power? From the United Nations Universal Declaration of Human Rights to courtrooms in the United States and South Africa, the idea of rights for all continues to face tension between what's universal and what's culturally specific. In this episode, we explore the key theories of human rights, natural law, cultural relativism, critical legal studies, and how they help us understand the values we all claim to share. Along the way, we'll dive into Jack Donnelly's powerful article from 1984, Cultural Relativism and Universal Human Rights, and unpack its relevance for the modern world. Let's kick it off with an overview of human rights theories. To understand human rights today, we need to look at the theories behind them, the ideas that explain where they come from and why they matter. The natural law theory says human rights are based on moral principles discoverable by reason or given by a divine authority. These rights are inherent and universal. No government can take them away. Legal positivism theory takes a different view. It argues that rights exist only because they are written in law. If it's not in a statute or a constitution, it doesn't exist. This approach grounds human rights in formal legal systems, not morality. This is a cultural relativism, which challenges the idea of universality. It claims that rights and values must be understood within the cultural context they arise from. What's considered a right in one society might be irrelevant or even offensive in another. Critical legal studies go further, arguing that law, including human rights law, is neutral. It reflects the interests of the powerful and must be constantly questioned. And across many parts of the world, religious and philosophical traditions like Islamic principles offer their own frameworks for justice, compassion, and dignity, sometimes aligning with global human rights standards, and other times clashing with them. These theories are the backbone of modern human rights debates, but how do they apply in practice? Thus way documents like the Universal Declaration of Human Rights, UDHR, come in. Now let's zoom into the UDHR. In the aftermath of World War II, the world stood at a moral crossroad. The horrors of the Holocaust, war crimes, and mass displacement called for a universal standard to protect human dignity. In 1948, the United Nations General Assembly adopted the Universal Declaration of Human Rights, or UDHR, a landmark document that defined for the first time a global version of what it means to be treated as a human being. The UDHR affirms that all people are born free and equal in dignity and rights. It sets our civil, political, economic, and social rights, including the right to life, liberty, education, work, privacy, and participation in government. While the UDHR is not legally binding, it serves as a common standard of achievement. Over time, many of its articles have gained legal authority through customary international law and inspired binding treaties like the ICCPR and ICESCR. It is more than a set of Western ideals. The UDHR, Universal Declaration of Human Rights, speaks out universal values. It protects not only cultural practices, but also the core human values that transcend culture, like freedom from torture, non-discrimination, and equality before the law. In a divided and diverse world, the Universal Declaration of Human Rights became a foundation, a blueprint for a more just global society. Now, let's look at the UDHR and the modern state. The modern state is powerful, capable of delivering justice, but also capable of violating rights on a massive scale. The Universal Declaration of Human Rights was drafted with this in mind. Articles 3 to 5 of the UDHR guarantee the right to life, liberty, and security of person, and strictly prohibit torture, cruel, or degrading treatment. These are rights held against the state to prevent abuse not just by individuals, but by the government. Articles 8 to 11 reinforce legal protections. They secure the right to fair trial, freedom from arbitrary arrest, and the presumption of innocence. These principles create a legal buffer between the individual and the state authority. Even Article 16, which addresses the right to marry and found a family, is not just about personal choice. It ensures freedom from state interference in deeply personal matters, protecting family life as the foundation of dignity. The UDHR doesn't just list values, it draws lines that states must not cross. It reminds us that rights are not simply privileges granted by government. They are claims against government grounded in our shared humanity. Now we move on to the core philosophical debate of cultural relativism versus universalism, using Jack Donnelly's 1984 article as the backbone. Can human rights be truly universal in a world of diverse cultures, religions, and histories? This is the central question explored in Jack Donnelly's influential 1984 article, Cultural Relativism and Universal Human Rights. Donnelly acknowledges an important truth. Cultures differ, and with them, so do moral practices. What one society calls a right, another may call a violation. This view, known as cultural relativism, argues that each culture has its own values and thus should not be judged by outsiders. At the opposite end is radical universalism, which says that moral rules and rights apply equally every way, regardless of culture. But Donnelly rejects both extremes. He argues for weak cultural relativism, which is a middle ground that respects cultural variation only within limits. According to this view, rights like freedom from torture or due process of law are so centered to human dignity that no cultural practice can justify violating them. At the same time, weak cultural relativism allows for variation in the form of interpretation of rights. For example, the right to political participation might look different in a tribal council than in a parliamentary election, but the principle of participation remains. In Donnelly's words, basic human rights are relatively universal. They apply to all humans in all societies, but allow for carefully limited exceptions rooted in a genuine cultural difference, not political convenience. Jack Donnelly describes cultural relativism not as a fixed idea, but as a continuum, ranging from strong to weak forms. Strong cultural relativism holds that culture is the primary source of the meaning and legitimacy of rights. It argues that most rights are culturally constructed, and only a few, if any, should apply universally. This view allows wide variations in what rights exist and how they are enforced. For instance, a strong relativism might accept that one country criminalizes same-sex relationships or restricts women's movements so long as it's consistent with local tradition. Weak cultural relativism, by contrast, recognizes that some rights are universal, especially those that protect human dignity in the most basic sense, but it allows for local variations in the form, application, or interpretation of those rights. For example, the right to political participation might look like direct voting in one place and council consensus in another. Both uphold the right, even if their form differs. Donnelly proposes that variation is acceptable at two levels. 1, the form of rights, how they are implemented. 2, the interpretation, how they are understood. But he draws a clear line. The substance of basic rights must be protected. In short, Donnelly tells us we can respect culture without abandoning human rights as long as dignity remains the guiding principle. Okay, now let's look at how rights are interpreted differently. One thing we know is that even when a right is recognized worldwide. How it is interpreted and applied can vary dramatically across cultures and legal systems. Take freedom of expression as an example. Article 19 of the ICCPR declares that everyone has the right to hold opinions without interference and impart information of all kinds. But it also allows restrictions when they are necessary for public order, morally, or the rights of others. In the United States, the Supreme Court in Texas v. Johnson, 1989, ruled that burning the American flag was a form of protected speech, even if it offended many. Expression, even when controversial, was placed above patriotic symbolism. But in South Africa, courts have taken a more nuanced approach. In AfriForum v. Nelson Mandela Foundation Trust, 2023, the court considered whether the public display of the Apraflad-era flag was a protected expression or hate speech. Here, dignity and equality were prioritized over unrestricted speech. These cases show that, while the right itself may be universal, its interpretation, how we weigh it against other values like dignity, equality, or public order, can reflect local history and moral context. Marriage is another example. Article 16 of the UDHR affirms the right to marry and found a family. But whether this includes same-sex marriage or how much say elders or communities have varies across legal systems. These are not rejections of human rights. They are examples of what Donnelly calls culturally grounded interpretation within the limits of human dignity. Although the Universal Declaration of Human Rights laid the foundation, it wasn't legally binding. To turn those ideals into law, the United Nations began drafting a single human rights treaty. But global politics got in the way. Western countries emphasized civil and political rights like free speech and fair trials. Socialists and developing countries pushed for economic and social rights like housing, health, and education. The result, a compromise, two separate but complementary treaties, which were the International Covenant on Civil and Political Rights, ICCPR, and the International Covenant on Economic, Social, and Cultural Rights, ICESCR. Together with the UDHR, these three documents form what we now call the International Bill of Human Rights. The ICCPR protects freedoms like expression, religion, and political participation, rights often violated by authoritarian regimes. The ICESCR covers essentials like food, shelter, healthcare, and education, rights closely tied to poverty and inequality. But there's a catch. Countries can rectify one without the other. And even then, they can enter reservations, legal exceptions that limit how they abound. The split reflects the tension Donnelly describes. Even as we agree on human dignity in principle, our political systems and cultural priorities shape what we enforce in practice. As we conclude, it is important to note that human rights are not perfect. They evolve, they are interpreted differently, and they do not always fit neatly into every culture or legal system. But as Jack Donnelly reminds us, they are not just cultural preferences or political slogans. They are grounded in the idea that everyone matters and that there are limits to what any society can justify in the name of tradition. The strength of human rights lies in their balance between protecting universal human dignity and allowing cultures to express values in their own way. That's why Donnelly calls them relatively universal. They apply to all people, but with limited space for cultural interpretation, never at the cost of basic human dignity. From the UDHR to the ICCPR and ICESCR, the global community has built a framework that defends the individual from unchecked power and affirms that justice, freedom, and equality are not Western ideas, but human ideals. As our world grows more connected and more divided, this conversation remains urgent. How can we promote human rights while respecting differences? There's no easy answer, but there's a clear principle: dignity first. If you found this video helpful, make sure to like, share, and subscribe. This is City Education, your channel for education in all shapes, forms, and sizes.